Thank you, everyone. You may be seated. We now have the fourth and final case that is being submitted today, State of Iowa versus Kevin Thoren. Ms. Stewart, on behalf of the applicant, you may begin.
Good morning. May it please the court, counsel. Again, my name is Ashley Stewart and I represent the appellant Kevin Thoren. The district court improperly allowed inadmissible character evidence when it admitted alleged incidents of sexual misconduct from 5 witnesses and when it allowed evidence in of a sexual misconduct investigation by the Iowa Board of Therapy. Under 504B, 5.403 and 401, all of this evidence should have been deemed irrelevant and prejudicial. In this case, 501, 502, 503, and 504 should be working in connection with each other. And of course, first, the decision should be made as to whether the evidence was relevant to any issue at fact. And here, the evidence was marginally relevant under a 501 standard. But then when you go to the 504B standard and you look to see if it's relevant under any of the 3 things that the state alleged, which was motive, intent, I believe, and absence of mistake or accident, it doesn't fall within any of those parameters to be allowed into evidence. But more importantly, if you can get past the initial 404B standard, it doesn't pass the prejudicial test, which is the crux of the argument here. I'll start first with the Iowa Misconduct Board of Investigation, Massage Board's investigation. First, by allowing that testimony in and allowing the jury to hear that this investigation, number 1, happened, and number 2, resulted in a suspension of license by Mr. Thoren, allow the jury to lean into that evidence and determine that if he was convicted or guilty in that investigation, that the same has to be true in the criminal phase. And that's an improper use of that evidence, and it makes it highly prejudicial. First, also because it's a different standard. Yes.
Are you conceding then that investigation is at least relevant to either motive, intent, or lack of mistake in this case?
No, I'm not conceding that. If we start with motive, I think the state alleges that it goes to show Mr. Thoren's sexual motivations. But the first thing here is sexual motivations wasn't an element to be pursued in this case. It wasn't something that had to be established. But also in all of in the investigation by the Iowa Massage Board, which was the interview of these 5 women, they all testified to different areas of touching. And so it didn't really go to show any particular or unique thing that was happening. Second, as far as intent, Mr. Thoren was obviously arguing that there was no touching here, and I think intent and motive are pretty much interconnected. I think it's the same argument there.
Charged with sexual abuse third, but was the jury instructed on the lesser included assault with intent to commit a sexual act, and does that bring specific intent into an element of the offense?
Yeah, I think that was an underlying charge, and there is case law that obviously says if there's assault that motive would be important or that the sexual motivations could be important. But I think the fact to lean into here is that, again, they're all different. All the women are testifying to different things happening, and a lot of times the touching of the breast area isn't deemed to be a sexual assault, and so I think it didn't really go towards anything pertinent in this case. It just really went to show that if it happened over here in this proceeding with the Iowa Massage Board, then it has to be a direct line that it happened here, which isn't in fact propensity evidence, which is what is supposed to be excluded.
But there's commonality too. The commonality is he's holding himself out as providing services in a very private setting. Yes, the nature of the touchings varied, but at 25,000 feet or maybe 10,000 feet or 5,000 feet, but at one level of generality, there's some commonality, and that is private, one-on-one, fee for service, and kind of a quasi-healing arts context. Is that enough to bring this evidence in?
Then the question obviously becomes, was this the evidence was this evidence needed to establish any of those factors? And here, this is a he said, she said. The evidence that was needed was the charging victim. That's all they needed. All of the other things that were piled on really just became a pile on to lift her credibility, but also to, again, show propensity and to show if he did it here, we need this evidence to booster the charging witness's credibility, and then for the jury to link it all together and say if it happened here, then it had to happen over there.
Correctly, there's a dispute about kind of the touching, and I guess his view is he touched the pubic bone and hers is different. Does that make it less relevant in terms of motive, mistake, et cetera? Because really, like you said, it's just he said, she said, and not, well, I did that, but that wasn't my intent. Does that make sense?
I think it goes directly to the absence of mistake and the lack of accident. That part of 404B, if he's not saying it was an accident or I accidentally touched her there. He's basically saying I didn't do this at all, and I didn't do it with the intent that they're saying I did it with. But mostly, he was saying I didn't do it at all. Like there was nothing inappropriate during these massages.
We have all these 404B analytical frameworks and all that, but we've also said, I think, like in the Putnam case, that it kind of comes down to how similar are the other acts, and they involved different individuals. That's true, but doesn't Justice Apple have a point that there are similarities in the acts that happened before? They happen in the course of his providing services for pay. The allegation is that he went beyond providing the actual massage or therapy or whatever he's supposed to be doing. And isn't that enough to sort of get you into an MO? It's not, then it becomes more than just he committed a crime before, therefore he's committed a crime now. Isn't that, you see where I'm driving at?
Where you're going. And I think that the question in Putnam that's really important in this case too, was the evidence only entered for the purpose of showing that the defendant was a bad person and he did these things, and was the evidence needed? And I think the answer to both of these is yes, it was only introduced to show that he had maybe allegedly done these things before, and so the conclusion can be drawn that he did it again. And then secondly, the evidence wasn't needed. The only evidence that was needed was the victim who the complaint was about, for her to testify as to what happened. Trotting in all of the other witnesses and bringing in the Iowa board, again, just boosted whatever, and boosted her testimony, but wasn't really necessary to the elements or to prove what needed to be proven by the state.
Does the state need to identify the legitimate disputed fact that's at issue before it can bring in this type of evidence?
So that's the crux of relevancy. It only is relevant if it's related to an issue at fact. And so in order to bring it in, you have to prove that it's relevant to that fact. And under 404B, you clearly have to prove that it's relevant to some of those exceptions, in this case, motive, intent, and then the absence of mistake. And without that, then the evidence doesn't come in. And
the board ruling, it seems very prejudicial. The jurors may think this has a stamp of approval of a neutral agency. But in that ruling, he surrendered his license. Isn't that akin to a plea bargain? And would Rule 410, that generally excludes evidence of pleas, be an additional ground to keep that evidence out?
I think the self-surrender came across like an admission of guilt. That's what it looked like, I'm sure, to the jury. And so when you say he's already admitted guilt over here, then it wouldn't be a stretch to find him guilty of the criminal charges over here. And that's precisely what made it heavily prejudicial. Aside from the fact that the Iowa Massage Board uses a different standard to even conduct their investigations and make their conclusion, a standard that's lower than the reasonable doubt standard.
Licensed professionals be reluctant to agree to settlements if they knew that that settlement document could be used against them in court?
And it's unfair to hold someone accountable for something that happened in a civil setting or versus what's happening in the criminal setting, which is what happened here.
Voluntary surrender of the license relevant to show that he didn't have a license, which in some ways was relevant to the scope of services he should or should not have been performing with the person in this case.
That was an issue at fact or something that was relevant to the case. The jury just needed to decide if a sex act happened and if it was against by force or against will. I don't think him having an actual license or not really played into that deciding factor. They could have decided that based on the testimony of the charging witness. So I don't think it needed to come into evidence. I don't think it was relevant.
He had surrendered his license come in through that victim herself. Didn't she testify that she had Googled him after the incident and saw that he had surrendered his license?
True. And I think it also obviously came in through the massage board when they talked about how he had surrendered his license on a date prior to this.
Was the evidence from the victim herself challenged in district court?
No. But I believe you're right. She did testify to Googling him and finding out that he didn't have that specific type of license. Of course, his answer was, I wasn't performing that specific type of massage for which I had no longer had a license for. So, but again, to Justice McDonald's point, I don't think that was relevant to any issue at fact in the case. So really, if you can get past the 404B exception and allow it in under motive intent, I would implore the court to really do the prejudicial balancing test, which I believe is what would really exclude all of this evidence.
Normally let district courts do. I mean, the weighing of those things, this court really isn't well suited to 403, right?
It's true that often the district court, because they're seeing the evidence in live action, that you give, they have the balancing test, they do more of the balancing test. But that doesn't mean that when they get it wrong, that you can't, this body can't come in and say, seeing the facts of the case, it was wrong. And I think it's clear that it was wrong here because 5 women testified about, 5 different things, though some of them were interconnected. And then the massage board testified about why he had to surrender his license. And I think this case is akin to Houston, which it's a DHS case, but again, it was a DHS investigator who came in and talked about all of the things that the investigation under DHS came up with and then introduced all of that into evidence, and the court found that that was prejudicial. And I think this case is very similar to that case, albeit not DHS, but still some outside person came in and testified.
Investigation of the same facts by DHS. And so in this case, we've got the board investigating different facts. And so I think from a perspective of, we don't have the problem here that the concern that the jury will substitute an agency's finding on the same facts for its own, but maybe it's more the bad acts that comes in.
Leaning more towards the bad acts, just the allowance of the prior sexual misconduct allegations to come in that were being investigated by a separate agency that wasn't a criminal court, that resulted in what was akin to probably be perceived as a guilty confession on the part of Mr. Thoren. I think all that still aligns itself with Houston and why it should be deemed prejudicial in this case as well. Are there any further questions? Seeing none, I will be back on rebuttal. Thank you.
May it please the court. The district court did not abuse its discretion in admitting the prior bad acts evidence. Given the facts of this case, the nature of the defendant's prior improper touches of other women illuminated his actions in this case.
Specific between intent, motive, lack of mistake, which ones of those does that prior evidence go to?
So this case is,
Goes to all of them, it's really propensity, isn't it? I mean, you're really asking him to make the inference that because he committed sex abuse in the past, he committed sex abuse this time.
disagree. The fact that this evidence satisfied almost all of the express exceptions to 404B does not make it a less strong case. It makes a stronger case for admission. So let's just look at the facts of this case. So typically, general criminal intent is not at issue in a criminal case. Here, it is. Also, typically,
Pushback, explain that. How is specific intent at issue in this case?
are, as we all know, that the touching occurred in the course of a massage. So under those circumstances, not because it was the specific defense of Thoren, but because the facts raised the question, was the touching improper? Was it deliberate?
Because I didn't touch that area at all.
It's also created a possibility, a strong possibility, that the jury could look at this and say, we don't think he touched her with criminal intent. We think he touched her with perhaps mistaken therapeutic intent, but still therapeutic non-criminal intent. So the very facts of this case make general criminal intent at issue. Furthermore, because there was planned touching, for lack of a better term, because the victim expected to be touched, because we know the defendant was permitted to touch the victim, the question becomes really central as what touching was okay and what touching was criminal. And so for those purposes, the prior touching shows very strongly that the defendant touched LR with criminal intent and that he did it for the purpose was a sexual purpose.
Generalized. So go through some of the other victims. So I think there was some evidence that he panted heavily during a massage therapy session. Tell me how that's relevant in proving that this touching was within the scope or not within the scope of therapeutic touch.
I think I will concede that is the least persuasive of the prior bad acts evidence, but it shows the defendant was acting with sexual purpose. And don't forget,
Show that. I don't.
the victim, the witness testified that she believed he was aroused by the touches, and that is not typical therapeutic massage behavior. And it shows he was doing things with a sexual intent.
Different set of facts. So let's say somebody's arrested inside somebody's house for burglary, all right, and says, well, I wasn't there to burglarize the house. Can you introduce evidence that they've committed burglaries in the past?
Burglaries that involve sexual contact? Oh. Okay, just a straight-up burglary. I believe you could, yeah, if its intent in being there was at issue. So
Talked about that the state has put on this type of evidence to rebut a specific defense position. And so if the defense was that the victim consented, then we allow the state to put on evidence to show that of other bad acts. So isn't it the state's burden to identify a specific defense position that evidence goes to? And what case support?
often what happens, but the facts themselves can raise a need for prior bad acts evidence. It doesn't have to be specifically the defense.
Allows you to just say generally the facts, that the state doesn't have to point to a specific defense position, just the facts in general allow that. What's your best case for that?
A specific case, I think, is kind of the general universal import of all the cases taken together. So, for example, though in Cox, though the court found specific situations where other victims' testimony would come in. So, okay, I can give you an example. There are situations where the defendant does not testify at all and really just takes the position of the victim wasn't credible. In those situations, there are innumerable cases where other witnesses.
Necessary? I mean, you don't know what the defendant's going to do as the state's putting on their case, right? I mean, you have to put on your full case. Right.
Rule 5404B that limits those exceptions to ones specifically raised by the defense. The facts of the case very often will, and in this case did, create situations where the jury will have questions. The jury's questions are what's at issue here, not the specific defense.
I often find in these kinds of cases, it's helpful to look at the prosecutor's closing argument, how they wanted the jury to take that evidence. So here's the rebuttal argument just before the case goes to the jury. And tell me why this is not a propensity argument. This is what the prosecutor says. When you go back, your job when you go back to the deliberation room is to decide, do you believe LR or do you want to believe Kevin Thoren's version of events? That's it. The two do not overlap. There's not gray area. You can decide based on the testimony of LR and for the purposes for which the jury instructions tell you you can. There's that little disclaimer. You can rely on any of the other testimony of the other victims. You can use it to show, was this a mistake? Was it an accident? Did he intended to do this to her? He's done it to 5 other women. Isn't that propensity evidence? Propensity use?
It's very closely paraphrases Rule 544B. Also, don't forget there's Rodriguez, where this court said that prior bad acts evidence can come in he said, she said situations to support the credibility of the victim. So even if I didn't believe that was a pretty good paraphrase.
It was the same victim. This would be 180 degrees a different case. I agree with you. But when it's different people, isn't that a propensity use when, say, he's done it to 5 other women, meaning he's committed the crime with 5 other women?
I mean, sure, you could read it that way, but I think first of all, you have to look at the first argument. The prosecutor first very carefully explained the purposes for which the other bad acts evidence could come in, and was very careful in its use in its opening argument, in its initial closing argument. So take the rebuttal argument in the context of the initial argument. I think then it's pretty clear. But also, we're really careful about using propensity, but 404B does allow use of prior bad acts evidence to show that the defendant was more likely to commit this crime. That's what makes it relevant. But the only thing we can't do is...
And the defendant saying, it was a mistake, I accidentally brushed by that area, I really didn't mean to. Wouldn't that be a much stronger case for the state?
But keep in mind that in this case, the defendant essentially blindfolded the victim, and then so that she couldn't see what he was doing. Then brought in expert testimony to say, people undergoing these procedures can have phantom touches. So she couldn't see what was happening. He's suggesting she improperly felt it.
Testimony about the difference between Reiki therapy, or I'm sorry if I'm saying that wrong, and massage and those kind of things. How does that fact, when we're talking about the facts of the case, the fact that this was Reiki therapy and not massage, which is what the other victims testified about, how does that play into going towards something besides propensity?
I think that doesn't make a huge difference what label we give it, because Thoren was not following the rules for those particular disciplines of therapy. He was touching the victims, and so the difference between therapeutic massage and Reiki and sacrocranial is not very much difference in this case. Going back to the mistake, though. So the example you gave was a straight-up classic example of mistake. But here there could be a different kind of mistake, equally permissible. The jury could have determined that the defendant mistakenly triggered those feelings in LR by touching her in places that he should have known to feel that. So that could be the kind of mistake that they would be looking at. And also...
Just McDonald's question. I think he may have identified your weakest of the 5. Tell us about your strongest of the 5 other victims for admissibility.
The strongest will be the victims who testified that he touched their genital area. So his sister-in-law, who testified about that he used the massager, and I'm forgetting the name of the other victim who said he rubbed over her genital area. Those are really close.
Up on that. So the cases generally talk about the prior bad acts calculus being something relating to kind of factual fit, you know, how similar were the prior circumstances, and then temporal proximity, because at some point these things become less relevant if they're old. So specifically with respect to the relative, tell me how that would balance out. So you have that's the oldest of all the events, if I
So I thought hers
years or something.
was, I can tell you when it was. Yeah, it was, we can agree it was old, yes.
Maybe the closest related to the allegations, whereas you have some newer things that aren't really so factually close. So how should we be thinking about that balance specifically with respect to the relative?
I think the balance is, stake and seize, these are all not identical to what he did to the victim in this case, but there seemed to be a progression. So he would touch someone's breast, close to their breast, they would complain, he would try something else. He used the massager, people complained, he quit using the massager, started using hands to touch. And it all kind of relates together also in terms of the investigation, because the investigation concluded 6 weeks before he assaulted the victim in this case. So all of those things work together to show that he had noticed that what he was doing was not proper, and that he continued to do similar or slightly different things or slightly more severe things. He kept evolving to fit what he could do and what he'd already been told he could, what there'd already been a complaint about. So it all kind of fits together globally to show his purpose in touching them was not therapeutic. His intent was sexual. And don't forget, because he was charged with third-degree sexual abuse, the state had to prove that he had a sexual purpose in touching LR. So they all fit together to show that he had that sexual purpose and that he knew what he was doing exceeded the proper bounds of massage. I think that's the best, perhaps, answer. Or maybe that didn't answer. You look like it didn't.
I just think it's a difficult issue, right? I mean, we have separate incidents. The admissibility of each one has to be independently evaluated. I think there's a risk of just kind of lumping them all together and saying they all come in or they all come out. And it seems like maybe there could have been some finer distinctions made between these incidents.
Could the district court have done a better job? That's probably almost always true. But what the court properly found was that all of these, taken individually or together, showed that the defendant was behaving in a sexual manner in the course of what should have been professional massage treatments.
Or so he did it again. Isn't that propensity, though?
The only thing that's objectionable, I mean, propensity evidence, I hate to say this, but propensity evidence in and of itself is not inadmissible. What's inadmissible is saying that the defendant has bad character and he committed this crime because of that. The fact that he's done similar things before, which we might want to call propensity, is admissible as long as we can tie it to some permissible purpose in this case. And here we can. This is a really sort of complicated case. I mean, we have a situation where touching is expected. We have a blindfolded, essentially blindfolded victim. We have the fact that he's told her before he touched her genitals, now I'm going to work in your genital area, which could in context mean I'm going to touch the part of your spine that has energies related to your genitalia, or it could mean I'm actually going to touch your genitalia, which is what he did.
Counsel, is the mistake part of this on the victim's part and not his part? Is that what you're saying?
I'm saying that in part. I mean, I think the jury could say, oh, if he touched her, he touched her mistakenly. But I also think 404B does not say that it has to be the defendant's mistake, and it also is not an exclusive list. So I think under the sort of strange facts of this case, yes, the victim's mistake would be to prove that the victim was not mistaken, would be a permissible purpose of the 404B evidence. And I actually think in this case that's a maybe it's one of the primary purposes for admission. So again,
You may wrap up.
under the facts of this case, the evidence of the prior victims is admissible to show the defendant acted with a sexual purpose in touching the victim. It's admissible to show, to help the jury resolve the he said, she said nature. It's appropriate to show the defendant's purpose and intent, and to show the lack of mistake both on the part of an accidental touching by the defendant and perhaps the mistaken perception of the victim, which the defense strongly suggested is what happened.
Stewart?
I'm just going to lean back into propensity here. And of course, those three targets that the state is talking about, the motive, intent, absence of fact, and lack of mistake, and the 5 women who testified. So I think Justice McDonald was right when he pointed out that these 5 women are testifying about very different things. Some women are saying, you know, he touched the nipple area or the breast area. Some are saying vaginal. They're all different. And of course, Mr. Thoren is saying that none of those things happened and they weren't inappropriate. And so I don't think taking all of those different types of touching creates the motive or the intent that the state was trying to align itself with. And then if you add on top of that, the years that it passed, 2008 was the oldest one. The sister-in-law was 2009, and there was another woman in 2009, then there was 2012, and then there was 2014. These are all very old. They're not happening in the same situation, in the same place, and I think that's what makes it different from some of the cases that were brought up in the brief, like plaster, which is something that was allowed because it was unique. It was something that the defendant was doing. It was kind of his modus operandi. That's not present here. I think in Pearson,
You reviewed kind of the cases all over the country dealing with this issue, and it's kind of unique to sex abuse cases because frequently there's a debate about whether there was a crime at all, right? I would say or guess that the vast majority allow this type of evidence. Do you disagree with that? And if you do, what makes this case, or if you agree with that, what makes this case different? And why should we not conclude the evidence was admissible?
it's generally, this type of evidence is generally allowed, but my argument is it's generally being allowed because it's really propensity evidence. I don't think the proper evaluation is happening here. It can't just be because I need the evidence to convict the defendant. I need the evidence to prove my case. It really has to go to one of those specific exceptions under 404B, and often it does not, but it's still allowed in. And I think if you go to the second half of 404B, which is the balancing, it's probably because the balancing test isn't being done either, which is what's the actual need for this evidence? And in this case in particular, there was no actual need for this evidence.
The argument that it's needed to show that the victim wasn't wrong about this happening, that the mistake wasn't on the victim's side as opposed to his side.
But even still, it doesn't fall into any of those exceptions that 404B mandates. So there isn't an absence of mistake. And I guess maybe it would fall into motive intent, which is what the argument is, that it's needed this was needed to show that what she was saying was true. But doesn't that make it propensity? Doesn't it say that in order to establish the truth of her testimony, we need to bring in all of this other evidence that will bolster her credibility?
He's saying, I didn't do it. She's saying, you did do it. And isn't there some argument that she might be wrong about it, right? Because of the nature of what he was doing. She was blindfolded. And that this shows that he'd done it previously, and so she's not mistaken about that.
And he said, she says, it comes down to credibility, and the witnesses are the ones that are needed for the jury to establish credibility. They don't need to, the other women didn't need to be paraded in to establish her credibility, which is what was happening here, which is why it was propensity evidence as opposed to something.
Propensity. That example I gave before where if he had said, I just accidentally, maybe I got bumped by somebody, I did not intend, it was a mistake. So if the evidence would come in under mistake, that also shows propensity too, even though it was correctly allowed, right?
I don't think it shows propensity because it goes to the absence of mistake exception to 404B, which
But doesn't it also, wouldn't it weigh in the juror's mind as propensity?
it could, but I also think because it falls under an exception, it's allowable. That's, that's just the rule.
But sometimes allowable stuff could also be propensity.
And you would go to that second prejudicial balancing test and determine, was it something that was actually needed or was it used for, another purpose? And so I think in this case, it is unique, but I do think that it fell into propensity more than it.
Case, it's not exactly clear always what the defense will do. Why shouldn't the state be allowed to put on its strongest case with its best evidence to prove all the elements of the case and potentially disprove defenses or arguments that the defense might make, but it doesn't know? So in this case, it was a denial that this conduct had ever occurred, but the state doesn't know that when they're putting on its case. So as a practical matter, why should the state be limited in terms of offering its evidence by the theory of the defendant on what's at issue in the case?
I see my time has run out, so may I answer that question, please, Judy? I don't think they were hampered in this case. They brought in the charging witness who was able to testify. They brought in an expert and that's where the expert testimony probably came in to be helpful. They brought in an expert to testify why this wasn't appropriate touching and what really happens in these Reiki massages and other types of massages. I think they were able to put on their best evidence, which is, again, goes to the heart of the balancing test. What is actually needed to prove the case? And what was needed was the witness, and then, of course, the expert helped the witness. So
Assume in this case the defendant had said, actually, I did do that touching, as alleged, but I did it for a legitimate therapeutic purpose. Would the state then be entitled to put on the evidence from these other victims to show absence of, or sexual intent?
I think that set of facts makes it different because Mr. Thoren, if those were the facts, would have been saying, look, I accidentally touched these places. And then, of course, it goes to absence of fact. And then, so it's.
He doesn't know that at the time they're calling the witness. So why can't they offer it into evidence under that theory? Because that is at issue in the case. It's always at issue in the case. Whether the defendant chooses to raise it or not is the defendant's choice.
State necessarily have to raise it in their case in chief. If that happens, you can call in rebuttal witnesses, you can do other things, but I think allowing it in just on its face, just because maybe the defense could make that argument, still makes it improper and makes it bad character evidence and being used for propensity, which it was used for in this case. With that, we ask that the case be remanded back to the district court and the conviction be vacated. Thank you.
The case of State versus Thoren is hereby submitted, and the court will adjourn for the morning.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.